Hi, everyone. I'd like to welcome our panelists, two of whom you've seen already today, so I'm not going to read bios for them, Drew Downing and Brian Hooker. John Gilmore is up for the first time today. He is the executive director of the Autism Action Network. He's an advocate who's worked for 25 years on public policy issues concerning autism, developmental disabilities, and vaccine rights and safety. Since 2007, he served as the ED of the Autism Action Network. It's a national nonprofit grassroots advocacy organization that influences legislation and policy on a wide range of issues impacting the autism community. He began his work following a vaccine injury to his infant son that caused extensive neurological damage, later diagnosed as autism. He's worked with a wide range of organizations, including Children's Health Defense, and most recently co-founded American Values 2024, the federal super PAC that worked to elect RFK Jr. as president. He has a master's degree in public policy from the Graduate School of Public Policy at UC Berkeley, and he lives in Long Beach, New York with his wife and his adult son. So welcome, John. I'd like to start actually, we want to keep things positive and talk about hope and movement forward in the future. We have to revisit the past sometimes to do that. But I would love for you to share the miracle in Albany about communication choice.
So I live in New York, and I do a lot of basically lobbying, mostly in Albany. I do some in Washington as well. We used to do a lot in Washington. Then once Obama came along, there's just like, it got to be hopeless, but now there's a lot of hope again. But anyway, and my son is a speller, right? And I think there's probably a lot of speller parents here as well, right? And the spelling is growing in New York like it is in a lot of other places, and we're running into more and more obstacles about, getting support for it. New York has some very generous benefits, but they won't pay for anything related to spelling. We also have problems like people who spell in group homes are not allowed to spell in the group homes and things like that. So a group of us parents got together and we put a bill together. This was, I guess, in about February, and it's called the Communication Bill of Rights. Right? And so we started plugging it, and I just knew, because I know, what persuades people up in Albany, that if we could get some spellers in front of the decision makers, we wouldn't even have to talk to them, right? It's a pretty stunning thing when you see what the spellers can do. And I was right. So we took around a group of spellers to a bunch of different offices and just had them start communicating with the people who were there. And we started this unbelievable momentum moving forward, right? I've worked on bills in Albany, like an autism insurance reform bill. Took us 8 years to do, okay? So we started in the end of February. We got it passed in the assembly about 6 weeks later, because just everybody thought it was insane what these kids could do. We took our spellers into various legislators' offices. More than once, the legislators were in tears, just because they were just sort of so stunned by what they were seeing and what that all meant. So we were the last bill voted in the legislative session of the Assembly, which ended last June. It was voted on at about 3 o'clock in the morning on a Saturday, and it passed 134-0. So, yeah. So we still have to go back and get the Senate to pass it. I'm very optimistic about that, and I think if we get it passed through those houses, I think the chances of the governor not signing it are just about zero. So this probably will end up, with a little bit of luck, and if they don't beat us elsewhere, probably the first sort of spelling-focused bill of rights in the United States.
John, do you think it's replicable in other
totally.
States?
Absolutely. I know there's a bill, because I read it. There's a bill in Florida. There's efforts in Massachusetts. I know there's other efforts all across the country, and I think if you can do it in New York, you could do it anywhere. There's also an effort at the federal level as well.
It's terrific, because spelling has opened a world for so many individuals with autism. Brian, you had said your son is a speller.
My son's,
well.
he's a speller. He just started on a keyboard last week. Woohoo!
My son, he is so neurologically impaired, he never could actually take an IQ test because he simply doesn't have the motor planning ability to like do what's required. And he's doing, well, whatever's beyond calculus. I don't even know what it is, okay? But that's what he's doing, right? I mean, you know, I kind of peaked at trig, right? So take it from there. And it's just, it's almost miraculous, really.
That is incredible and so hopeful for so many, so many families and individuals. And there's growing support from other organizations. For a long time, I know we got pushback from the speech and language pathology groups.
Yes, they were kind of like, you know, and I wasn't really surprised by that because they sort of against everything that's new when it relates to communication and in people on the spectrum and things like that. I don't know what the current status is on ASHA and spelling. Have they changed? Does anybody know?
No, they have not changed.
They haven't changed. Okay, so they're still opposing it. Yeah. I'm thinking they may not be as nearly as you know, enthusiastic about their opposition, right? I don't know if this is something they really want to fight, but we'll find out.
Okay, so to turn back a little bit to the past. John, in what ways, you've been in this a long time, all of us have been in this fight for a long time. In what way has justice been denied to individuals with autism and their families?
God, where do you start? You know?
How much time do we have?
We have 38 minutes. Go for it.
I mean, just the most fundamental, you know, tenets of justice in the, you know, Anglo-American jurisprudence have been denied our kids, right? And the most glaring example, obviously, is the denial of our kids' Seventh Amendment right to go to court over an injury, right? That was taken away from them by the 1986 Act. I mean, you can't get any grosser than that, right? And I think going forward, I'm very optimistic about the future for a whole lot of reasons, right? But I think one of the things that we as a community have to do is it's got to go. We got to get our right to go back to court, right? And I think if we get that, a lot of other stuff is going to take care of itself, okay? If the doctor's got to think, no, wait, man, I could be sued here, right? Likewise with Merck and the other ones, then I think we're going to see a real change in behavior. You know, I think if we do that and we get rid of mandates, which Florida is already attempting to do, and they kind of got there in Idaho already, we're going to be in a very, very different world. And I think at least going forward, you know, our kids are already injured, right? But that will sort of basically return not only their, you know, their constitutional rights, such as the Seventh Amendment, it also restores to them the obligation of the government on all levels to consider their well-being and their rights and their lives in the decisions they make, which they certainly do not do now.
I used to say, when I first started my practice, I started doing products liability defense work. And I used to say, when people would ask about that line of work, I used to, even doing the defense side of it, I would always say product liability cases were the check and balance. That's the check and balance on industry, because you can regulate, you know, regulators get into people's back pockets, and there's you know, revolving doors with regulatory agencies and so forth. But the product liability lawsuit is the check and balance on curbing industry enthusiasm over putting products on the market that haven't been truly tested.
Yeah. I mean, one thing that Kennedy says all the time, and it's the core of our problem, is that every institution we have to protect people from bad, dangerous products has been eliminated when it comes to vaccines, okay? We can't go to court, okay? What else do we have? Well, you have the market, right? You can choose not to do it. Well, we don't have that either, do we? At least with kids, right? And then on the other device we really have to protect us from dangerous products are the regulatory agencies, okay, which are completely bought. The last one we have is the press, right? And the legacy press is beyond repair. A lot of people were saying stuff trying to influence New York Times and stuff like that. I don't know if the New York Times is still here. I don't think we really need to worry about the New York Times, okay? Because one of the things that, I mean, if you go on this adventure that many of us are on and being an autism parents, everything we do almost is alternative, right? We do alternative medicines with our kids. We have an alternative way of looking at that. Our approach to food is definitely alternative, right? Our approach to education is alternative, right? So when you're talking about kids and you're taking out medicine, food, and what else? Education, what have you got left, right? And you know, this is not just limited to our community here, but I mean, there's this whole new media world that has developed that is really making the old media world, represented by the New York Times and ABC and CBS and all that, completely irrelevant. It's like someone earlier today quoted Buckminster Fuller, who said that, you know, if you want to change the world, design your own system, right? And we've been designing our own system for decades, right? And the thing is certainly with, you know, Robert Kennedy being Secretary of Health, our system is gaining power and influence and size very, very rapidly. So I think we just need to keep on going on, and eventually the sort of the old world, hopefully, will basically die a quick death.
Well, right, and taking away any liability for the manufacturers disincentivizes them from making a safer product, right? They're not going to lose any money. Now, Drew, the VICP originally was intended, it's my understanding, to be sort of a non-combative way that people could get compensation for vaccine injury. What has happened to that program?
Yeah, the good old days. So when I first started in the program, you could articulate a cause of action, say it was, you know, vaccine related, if you could support it with medical literature, or maybe in a rare instance you'd have to get an expert involved, but usually you could get those cases resolved. That includes encephalopathic regression. Those cases were, I think we talked about that this morning, those cases used to be routinely compensated by the vaccine program as an encephalopathic event. So in the 90s, HHS sort of changed the game by rewriting the vaccine injury table, which is the definitional section that sort of governs how the vaccine program works. But more recently, the Department of Justice that represents the Secretary of Health and Human Services in the vaccine program sort of seized control of the decision making in the program for at least probably the last 10 or 15 years. And imagine if you put a bunch of lawyers together and say, what do you want to do? You want to litigate? Because you're a litigator. So that's what happened. It started around the same time as the omnibus proceeding, and has gotten worse since that point in time, to the point now, which is sort of why I'm here, is that it is nearly impossible to win a vaccine case now, regardless of injury. If it's a questionable case or has to be defended, some of the special masters have above a 90% denial rate on litigated cases. And when a program was designed to compensate victims in an area that we may never know for sure what caused the injury. We can't prove vaccination did something. We can't prove infection did it. We just have theories. We can prove it with animal models and support it, but you don't know for certain. So the point there was, since we don't know for certain, we need to compensate. The close call goes to the victim. That is how the vaccine program was originally designed, and it's been hijacked, for lack of a better word, hopefully not for much longer.
Brian, if you could talk a little bit about your perspective on the Omnibus Autism proceeding, the OAP, and what you'd like to see as compensation for families of children with autism who are vaccine injured.
My family was in the OAP for 16 years. We filed in May of 2002, and because of a statute of limitations, could only include my son's 15-month vaccine. So any contribution then allowed the DOJ and their experts witness to say, oh, he was tugging his ears at 6 months, so we must have autism because he was tugging his ears. Definitely couldn't have been the ear infections that he was having over and over again, but yeah, it was autism. And the other thing that was laughable was really that it was going to be a friendly process. It was highly contentious. We could not find expert witnesses because any of them that had any experience witnessing for the petitioners, as an expert witness for the petitioners, had already been eviscerated and had committed career suicide by stepping forward as an expert witness. And these individuals, the special masters, we had George Hastings as a special master. He went to lengths to make sure that he tore down our expert witnesses to, the very core. It was like watching one of the old Flintstones episodes where Fred Flintstone was in with his boss, Mr. Slate. And then Fred would shrink and get smaller with every criticism, every slam. That was what it was like. And then finally, we were thrown out of the system because of a statute of limitation, and we never got oral arguments whatsoever. Neither did we get any type of compensation for the amount of money that we spent for legal fees. And so it was a net loss. These children need to be taken care of. My son is very, very similar to your son, John. Really, really brilliant, loves physics, loves calculus, loves German, but his whole body dyspraxia just traps him in his body. And so, bar another medical breakthrough or miracle, then he's going to need a lifetime of care, just 24/7 care. And so these kids, there needs to be some type of endowment for each child that's been affected for this in order to take care of them for the rest of their lives.
If I could add something to that, though,
absolutely.
because my son was in the omnibus as well. And one thing that I think we have to talk about is the omnibus has to be revisited, because and I agree with Drew. Earlier today, Drew said that the omnibus was a setup from the beginning, right? That it was going to be a way to get all these cases, put them together, and then just find some way to get rid of them, okay? But in the omnibus, they completely violated their own rules, and they violated the law in multiple places, because what they decided to do was pick 6 test cases to test various theories of autism causation, right? Well, 2 of them, one was Hannah Poling, okay? That was just outright autism, and they said, oh, no, that doesn't count anymore. And then there was another one where, based on an expert witness, okay, changed their opinion about what caused the autism in the individual concerned. So there was another one. But the lawyers for the government never let that testimony, that changed testimony, come back into the system. So you already had 2 out of the 6 saying, yeah, it was autism, and they completely disregarded all that, right? I can't imagine a more immoral, illegal thing to do. And at the very least, it has to be investigated, if not just completely reopened, with a look-back provisions for other families as well. I mean, this 3-year period is just insane. If it's any other kind of injury, correct me if I'm wrong, Drew, but if it's a medical injury, you have until a minor is no longer a minor to file. And we got 3 years with vaccines. Yeah,
it's part of the fallacy, and certainly something that I have flagged. Now we need the legislature to weigh in on that, because that's in the statute itself. So we have to statutorily change the statute of limitations. But yeah, it's a situation where it's 3 years from the first onset of symptoms, period. It doesn't matter if your child is 5 years old or not. The parent has the responsibility to file within 3 years of onset, even when every other state and federal statute of limitations period allows for a tolling when the child is a minor. The vaccine program doesn't have that. Specifically, doesn't allow for tolling based on the age of the child. So yeah, it's a travesty. Most people don't know that they've been injured or have put two and two together that it was the vaccination that did it within 3 years.
And I can speak from personal experience. We were not in the OAP or in the VICP because of the statute of limitations. My son, when I finally learned about the VICP, because I never got a VIS for any of his vaccinations, a vaccine information statement, which does mention the program, we were barred. I got all his medical records, and there was a notation on his record that said PDD NOS ? And that was it. We were out of time. It was beyond the 3 years. And lots of families are in that situation. But I think it's also important to talk about the way the program was set up as non-adversarial, and because of that, and John, you sort of brought up some of those general rights that people have in we'll call it the regular court system, states and federal courts, where you get discovery from the opposition. You get information from them. You take depositions and get sworn testimony. You don't have that in the VICP as of right, and you also have to keep in mind that you're not suing the manufacturer. You're suing the United States government, the Department of Health and Human Services. So if you want information from one of the manufacturers, that's called third-party discovery. That's almost impossible to get in VICP. I don't know, Drew, have you ever seen anyone get third-party discovery?
No, I've tried it multiple times, but not in the last 10 or 15 years, because I lost every single time. How valuable would it be to be able to get data from the manufacturer showing how much this was actually reported in the field clinical trials or anything like that, and there's none of that.
And can you talk a little bit more, Drew, about the OAP and some of the things that went on in that program that both John and Brian have alluded to?
Well, sure. I mean, and I think John just summed it up in the same way I did this morning. There were more and more cases being filed with the label of autism in the medical chart and being the focal point of the petitions in the case. So the court decided that was going to be what they were going to do for judicial economy and so forth. They were going to lump these in. They had you file a short form petition, so you didn't even file a whole petition or get to plead your case. It was a short form that basically just turned your child into a number, and then they used that. They lumped them all together. As John said, the test cases were stacked. The deck was stacked against the families from the get-go. The case that John was referring to. And I know, Kim, you're familiar with as well. They used an expert, a neurology expert, who came to hear the petitioner, the plaintiff's neurology expert, testify. And after the plaintiff's expert finished testifying, the government's expert in close quarters told them, look, I'm not sure that this little girl has autism, but I do believe a vaccine could cause a regressive autism, without a doubt. That is my opinion. So don't go back in there and say that I am giving some sort of a general causation opinion. And they fired him that night. And then used the transcript from the first trial as his testimony in the subsequent test cases. So that has been an issue for a long time, but that is definitely something that would warrant, and Kim and I have talked about this. It would warrant a Rule 60 reopening of that whole thing.
And there is litigation surrounding that ongoing right now, so that is happening.
Yeah, Like I said this morning, I mean, I didn't refer any clients to the omnibus proceeding because it looked to me like it was a setup. You know, you had individual families that were winning cases based on a regressive encephalopathic event. Most of those cases had autism in their medical chart, and by allowing the court to lump them all together like that, it was just a recipe for denial. It was going to get kicked.
Yeah, you know, this is another, I think, real injustice that we as a community have to deal with, is just the whole idea of, and the term and the use of autism is used continuously to hurt our kids. We got a direct example here, because in the vaccine court, if it says any autism anywhere in the kid's record, forget it, you're not going anywhere. But it's much greater than that, right? Because, I mean, you know, in the current DSM, right, we've got level 1, 2, and 3, right? That's sort of a step in the right direction. But we're in this bizarre situation where you can have an individual who is nonverbal, who doesn't have bowel or bladder control, and no effective way of communicating with the world, and needs constant 24/7 care, right? And then you could have somebody who has a successful career in a demanding profession with graduate degrees, a spouse and children, and both claim that they have autism, all right? And obviously, if that's the range of the spectrum is meaningless, right? We have to get away from that. We have to get away from the behavior-defined criteria that we see in the DSM-5, and we have to go to the actual biological problems that our kids have, okay? They have various kinds of physical injuries or reactions, diseases, whatever you want to call it. That's what we have to look at, right? And I'm not saying that people sort of the quote higher end of the spectrum don't have issues. I'm sure plenty of them have lots of issues, but they're not the issues my son has, right? And what you would do for my son is not what you would do for, you know, Jerry Seinfeld when he was saying he was autistic, right? And it's also used against us in the science, right? Because if you have a group of people, if you're trying to find out what causes autism, what is, you know, what kind of correlations you have there, and you have, you know, a denominator that is as huge as we have for autism right now, it's basically impossible to prove anything. Because, you know, you don't, if you have, say, specifically, say like you're looking at some sort of treatment for GI issues in people with autism, right? You can make the pool big enough to come up with any conclusion you want, which I think they do all the time. Which is why after 25, I think one of the reasons why after 25 years, we have virtually no treatments out there for the specific physical problems our kids have. I mean, that was one of the big deals about Monday, right? They actually talked about leucovorin as an actual treatment for a physical problem of autism. We haven't had, that's it, that's the first, which is just stunning. I mean, it's been what? When was the, remember the Combating Autism Act? Okay, that was 2007, right? We're almost 20 years in to a specific targeted research program on autism that hasn't yielded anything, okay? I mean, when my son was born, I say this all the time, but when my son was, not when he was born, when he was diagnosed 25 years ago, okay? We didn't know what the causes of autism were. We didn't know any treatments, okay? And we thought that the autism rate was about 1 in 500, right? Here we are 25 years later. We still don't have any treatments. We still officially don't know any causes of autism. However, we say the autism rate is 1 in 31, right? But we're still not sure if it's actually gone up. Well, what have we been doing for the last 25 years? Nothing.
No, and there are, you know, I think Honey mentioned earlier IVIG, or I'm sorry, that was Sylvia who mentioned IVIG. Many people with autism benefit from IVIG, but unless you have another diagnosis that insurance is going to cover, IVIG is incredibly and prohibitively expensive unless you're literally a multimillionaire or billionaire, pretty much. So there are treatments that are out there that are effective, but people just can't access them as well.
Right. You know, and again, if you say it's autism, forget it, you're not getting it. So we got to get rid of autism in more ways than one.
I think that's right.
Yeah. I just to shift gears, I don't know if you were going to ask another question in that regard, but I before we run out of time, I have to tell a funny Mercury story. There actually is one.
No one's ever said that
yeah,
before.
So I had an expert from the University of Arizona who specialized in what's called arsine gas. It's a arsenic derivative that they use to make semiconductors because it's heat resistant. And so arsine gas is actually mustard gas that they used, you know, for years and years in the military. And so I started talking to this expert, like, how on earth did you end up working in this area with the most toxic substance on the planet? And he looked at me and he said, you know, I used to do work in mercury, but it was too dangerous. So that was his story. So anyone that tells you that it's okay to put mercury in vaccines is just full of it. So anyway, sorry, I just went. That always stuck with me. It's like, okay, how can you say that we're talking about mercury and it's okay? Because the guy who would work with mustard gas thought that was going to be a safer vocation to take up. Anyway, sorry. Go ahead.
Put some perspective.
Okay. So a lot of what we've talked about here is a dwindling trust in public institutions from the American people. John, do you have thoughts on what can be done to redeem some of that trust and make people respect institutions again, possibly? I mean, we talk about the science never being settled, yet we have Anthony Fauci telling us he is the science. He is unsettling, I'll give him that. But
yeah, I think one thing you have to do is Bobby has to clean house, right? And he seems to be doing that, right? And the faster he does that, the better. But the thing is we can never go back to the old way, okay? That system failed, okay, completely. I mean, that's the whole idea behind MAHA, right? We've got the sickest generation of kids ever, right? So the current system doesn't work, right? And I think a couple of the key things in there is, one, you can't have any forced medical procedures, okay? That's got to stop. The stuff we were talking about before. Another big problem is almost all the research funding in the United States comes from the NIH, right? And they rigidly enforce orthodoxy. And I don't know the way around it, but you cannot have one source of money telling everybody in medicine what they can and cannot do. But I think we're going to have to go to a system, and one of the things I think is really interesting about what the ACIP has started to do already, which is freaking everybody out, is that they are returning responsibility to physicians, right? For example, with the COVID shots, right? They're saying, this is our recommendation. Go talk to your physician, see if it's good for you, and then you can do it, right? And lots of people we want a rule for everybody, that nobody out there, doctors, whatever, individuals can exercise their own decisions about it. We've got to re-empower physicians to be physicians and not algorithm followers.
No, and I think, we talk about abolishing mandates, and we've seen what Florida's done, what Idaho has done, what other states are trying to do. But while we work toward getting rid of those mandates and restoring choice to people in medical decision-making, I think we also have to think about religious exemptions, philosophical exemptions, and medical exemptions, because those are protecting those or restoring those is an important stopgap while we work toward medical freedom and abolishing mandates. And every state has a medical exemption. In most states, they are incredibly difficult to access. They get turned down routinely. They rely on standards that aren't even real standards. So they say, well, ACIP says these are the only reasons you get a medical exemption, but that's not actually what the ACIP guidance says. It says you can consider these things as examples. So we just had a case in New York that CHD supports, Doe against Oceanside. It was against a school district, a girl who was missing one hepatitis B shot, and she had 6 or 7 medical professionals saying it could be catastrophic if she got that shot. She had had very serious reactions to other vaccines. She has autoimmune diseases. She has a whole list, a litany of adverse reactions to vaccines. She even was she tried to convince someone to take her to an urgent care to get the vaccine because she so desperately wanted to go back to school and be with her friends. And the urgent care looked at her and said, no, we can't do that. We took that case to court, and Sujata Gibson, who's a lawyer that CHD works with on in many cases, got a preliminary injunction that allowed that girl to go back to school in September, where she belonged. And John, are you hearing anything in New York as a result of that case?
Yeah, I mean, medical exemptions has been a real big issue in New York for a long time. They were difficult to get forever, but in the last couple of years, the state actually started going after existing medical exemptions. Just kind of kids who had had a medical exemption for 10 years, all of a sudden were getting them denied.
And the doctors that wrote the exemption.
Oh, they totally go after the doctors who write the exemptions. But fortunately, we've got a really good law. The law in New York is real straightforward. It says that if a New York licensed physician thinks a shot may harm a person or a child, student, then they get a medical exemption. And over the years, the health department has perverted it into this sort of complicated system I won't go into that basically guarantees that most people are not going to get an exemption, right? And what the CHD suits did in this and some other decisions as well recently is they've actually been able to restore in federal court the sort of plain meaning of the actual law and sort of overrode all these regulations the Department of Health came up with to basically take away the physician's choice. Again, give the physician the choice back, right? And there's this one lawyer who's been working on as well with Sujata and with Kim, Chad Davenport, who's been very aggressive at going after schools. And the word is getting out that the law is the law, right? And so where it seems to be going now is that basically if you can get the physician, which is always a trick, but there are a few brave physicians out there who will do it, to sign the medical exemption, basically the schools are backing off, and so is the Department of Health, at least for the time being. We'll see.
No, it's been a huge win for families in New York whose children have real medical contraindications to vaccination. John, are you seeing anything on trying to restore the religious exemption in New York and in the other states that have removed religious or philosophical exemptions?
Well, you know, I think at the state level in New York and the other deep blue states that have repealed it in the last few years, I think it's going to be very difficult to do at the state level, right? But
what about the Grace Act?
That's it. But at the federal level, it's definitely possible, right? There's the Grace Act. Representative Matt Stubbe from Florida introduced a bill basically telling the states that do not offer religious exemptions that you have a choice, either offer a religious exemption or lose your federal education money, right? Yeah. One or the other. It's your choice. You do what you want, right? So, beautiful. And there's only 4 or 5, if you want to include West Virginia, states that don't allow religious exemptions, but that's where 20% of the American population live, right? So it has a pretty big impact. And another thing that's going on, there's been a lot of sort of noise about the possibility that there may be an executive order that does what the Grace Act does. Who knows? We'll see. I think if we put more pressure on the president to do it, he may do it. Who knows?
So Drew, I want to share with you something that someone in the audience who is I'm not going to name names unless they want to be named, has said about, he's very involved in the VICP, that when the petitioner wins, the special master settles the case and there's no written statement. The special master only writes opinions when the petitioner loses. And then the petitioner also signs an NDA, a non-disclosure agreement, if they win. What's your take on that?
That is not entirely correct. So what happens is if the case is settled, it can be an out-of-court settlement, just like any other thing, but the vaccine program still has to issue a judgment because that's how it gets paid out of Treasury, who oversees the Vaccine Injury Trust Fund. This is not taxpayer money. It's all funded through a 75-cent excise tax on the vaccines that are covered in the program. So when it's settled, there's a settlement agreement that is signed, but that still has to be filed with the court, and the court will enter a judgment adopting the parties' settlement. That's how it gets sent over to Treasury. If it is litigated, win or lose, there is a decision that gets issued by the special master overseeing the case. These cases are bifurcated, meaning they take up entitlement or causation first. And if the petitioner wins on causation, you move to the damages phase. So in some instances, there's two decisions that are issued, but there is always on a litigated case that is being litigated on causation, win or lose, there is a published decision that gets, well, it's not always published, but you can find it online or on Westlaw. So that is, it's not entirely true, but it's also hard to find. It can be very hard to find those decisions. They used to post them on the court's website. They've taken that down. So now you either have to be lucky enough to stumble across it in a Google search, or you have to have a pay service like Westlaw or Lexis where you can actually put in the search parameters that you're trying to get.
Do you feel like there's a tendency in the program, and I don't know the answer one way or the other, to push cases that are sort of cases that would be likely to win towards settlement?
Yes. Now, the Department of Justice doesn't always listen to that, and I don't know that it's any sort of evil intent on the special master's part there, as much as it's just a case on their docket. And if they can guide the parties towards an equitable resolution of it where everybody walks away happy, then so be it, and it's one less case that they have to adjudicate. But there definitely is some special masters more so than others. I wouldn't. I am willing to read a lot of ill will and intent into some of the special masters' conduct and what they do with cases and how they treat petitioners in the program. I wouldn't necessarily attribute ill intent to that component of it.
You mentioned the 75-cent excise tax.
Right.
Explain how the program is funded and who's really paying ultimately for the compensated cases.
Sure. So the excise tax, a vaccine cannot be added to the Vaccine Injury Compensation Program until Congress passes the 75-cent excise tax for that particular vaccination. The manufacturer pays that. So if a vaccine costs $100, 75 cents out of that goes and is sent as an excise tax to the Vaccine Injury Trust Fund. So it is the manufacturer essentially buying the liability shield with 75 cents to be given to a victim out of the Vaccine Injury Trust Fund. The problem is that there's almost $5 billion in the trust fund right now, and the trust fund made more in interest on its investments last year than it paid out in claims.
Wow.
So the system in that regard, it's, again, I think I've said it 3 times now today, it's broken, and it's not taking care of victims the way Congress originally intended.
John, did you have something you wanted to add to that?
Nope.
You look like you might. Drew, what changes, and I know you can't speak to specifics, but what changes do you feel are necessary for the VICP to be successful?
So I can talk in generalities, I suppose. And let me start with the liability protections. I know that's it's an issue, it's a big one, and it's one that everyone is concerned about. Here's what I see as a problem. Just basically collapsing the vaccine program is probably not the best solution. The catastrophic case could go and retain a lawyer and, you know, be able to have a lawyer agree to represent them in a lawsuit against the manufacturer or the vaccine administrator. The typical case, though, in the vaccine program is shoulder injuries, when they give the shot too high on the shoulder, or cellulitis, or what are called monophasic injuries, where it's really bad for 6 months. And then the person starts to make a recovery, either by using IVIG or some other autoimmune mechanism. So just simply getting rid of the vaccine program is problematic, because the $75,000 case can't get a plaintiff a lawyer to represent them. They would not be able to fund the case like that. It would cost more in experts than they could hope to recover. So the vaccine program still serves a vital interest for those folks. Partly, getting back to a question you asked earlier, I also think one of the ways to reinstate some public trust in the system is to take care of families when the horrible adverse event occurs. You know, if they'd taken care of the autism families in the OAP, you wouldn't be here. Most people wouldn't be here. They would have gotten compensated. They would have gotten benefits for their child. They would have gotten lifetime care, residential. That all would have been built into a life care plan, and they would have been taken care of. And it's the same with most injuries. So, you know, there are the good old-fashioned changes that everyone wants to see, changes in the statute of limitations, changes in the number of special masters. You know, most cases right now, I think I mentioned it this morning, there's almost 4,000 cases backlogged in the vaccine program. There's only 8 special masters, and you know, that backlog is just continuing to grow because they just can't get to cases fast enough. You know, requesting more special masters and things like that. Those are the good old-fashioned ones that have been in every bill introduced over the last 15 years. But there are different ways and different approaches too. You know, how HRSA, which is the division within HHS that oversees the vaccine program, you know, how they internally handle cases. You know, settlements, medical review, things of that nature are also being looked at to expedite handling. In the original act, and it's still in the statute today, the government was supposed to respond to the petitioner within 90 days of what their position on a case was. Most cases now take 6-7 years to resolve, and some even longer than that. So there are a bunch of changes afoot, and that's probably about all I can say about them.
Okay, well, on that note, I think we are out of time, gentlemen. Thank you both, and thank Brian in absentia. Yep. He had to leave for an emergency.
Thank you so much.